Hi, Tony DeWitt here, Missouri appellate attorney and a guy who answers questions on YouTube. Today we're going to talk about lawyer ethics. I know there are a lot of you out there who don't believe that there is such a thing, but there is. And I'm going to show you in just a moment how that works in the context of a complaint that's been filed against the St. Louis City Prosecutor. So if you'll stand by, I'll be with you in just a second. One of the things that most people don't know, if you live outside the state of Missouri, is that there are actually two St. Louises. The first St. Louis City, is the downtown area, and it is, in addition to being a city, a statutory county, so it has its own prosecuting attorney. And then that's the sort of the whole of the donut, and then the donut is St. Louis County. And St. Louis County has its own prosecuting attorney as well. And this case involves the St. Louis City Prosecutor and an ethics charge that's been filed against her. Now, I want to make one thing perfectly clear at the outset. At this point, all of these things are allegations. Nothing has been proved, and that we have to give the benefit of the doubt. In this country, irrespective of your status, you are accorded a belief that you are innocent until proved guilty. And in this situation, it should be no different. Ms. Gardner is to be considered innocent unless and until an ethics panel comes back and says she is guilty. That said, the allegations that have been raised against her in a 73-page complaint are serious and far-reaching and demand to be explained and looked at, and people, the more we have an opportunity to understand the underlying conduct, the more we can understand why an ethics complaint was filed in this case. Now, Ms. Gardner believes that racism played a big role in her being attacked in this way. She's entitled to her opinion. However, I can tell you that the violations that are listed in this complaint are serious and don't appear to be based on racism. So, today we're going to take a look at only one series of violations that's in this complaint. I'm going to link the complaint down below, and I'm going to recommend that you go and read that complaint if you're interested in this. We're going to talk about the violations of the duty of an attorney to correct perjured or incorrect testimony. Now, sometimes when a client testifies or a witness testifies, they get things wrong. It's okay to get things wrong with an honest, good faith belief that you're telling the truth. It is not okay to get things wrong when you are trying to conceal information, hide things, or not tell the truth. And it appears that the investigator that Ms. Gardner hired was attempting to do just that. He testified that he did not take notes.
And at that interview, you did not type out anything while she was talking, and you did not write down anything while she was talking.
I wrote out the preamble, the predicate of what we discussed, saying why we were there and who she was, whatever, which is in the preamble of the thing. And then I also made a note that just a handwritten on the bottom, date 129.
As a former FBI agent, you sat through a multiple-hour interview asking a woman detailed questions about her activities that are the focus of your investigation, and you took no notes and typed no contemporaneous information down and just sat there
until
and
she
listened.
left.
You put nothing to paper until she left, except the preamble.
Thank you. That's what I did.
And told him that he had never made notes during the course of his investigative career. He made those statements in front of Ms. Gardner when Ms. Gardner was present at the interview where he took notes. Now, when an individual testifies falsely, as the rules set out, You have to correct that. At that point, when he testified falsely, she should have taken a break in the deposition, pulled him out, and said, you have to fix that. You've either made a mistake or you've purposely testified falsely. Either way, you have to fix the mistake or I'm going to fix the mistake. That's what an ethical attorney is required to do. And ethical attorneys do that every day across this country. Our law license is way more important than one individual case. We have a duty to protect our law license. And in order to protect our law license, if a client lies, we have to make sure the court knows that. And I have even pulled clients out and had them correct minor technical errors because we have an obligation to present truthful data to the court. Ms. Gardner didn't do that. In addition, after testifying this way, they presented this evidence to the court in numerous situations where she could have revealed that there were notes and bullet points and other documents that were produced by the witness and by Ms. Gardner herself. She didn't do that. And this last bit of video is where he tells the court that the videos just simply didn't work.
And why didn't you record Katrina Sneed's interview?
The equipment malfunctioned, sir. It malfunctioned. We turned it on, and it didn't work.
There's not a single question or a single answer that was recorded?
No, sir.
That's what he said, but in the course of the complaint, it's revealed that the video did work, but that at some point, even though the video had its audio stripped from it, and nobody could figure out why that happened, the video did show him taking notes, and it showed him taking notes on the documents that Gardner had given to him. In order for you to understand a little bit better about where we're going with this, I'm going to show you some of Missouri's ethical rules. And you can find them online at www.courts.mo.gov. And look for Rule 4, which is the rules governing the bar and the judiciary. And one of the first bar rules is that of candor toward the tribunal. A lawyer shall not knowingly make a false statement of law or fact to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. Failure to disclose legal authority, and then offer evidence that the lawyer knows to be false. If a lawyer's or a lawyer's client called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. Ms. Gardner was present at his deposition, and the rule requires that you let the court know when someone testifies falsely. Normally the process is you take a break, you say, excuse me, I need to talk to the witness, you call them out in the hall and you say, look, you didn't tell the truth. If you don't tell the truth, if you don't correct this on the record right now, then I'm going to have to correct it, or I'm going to have to withdraw as counsel. Now in her case, she couldn't withdraw as counsel because she's not his lawyer. But what she could do, because there is no attorney-client privilege between the two of them, is make the information known to the court that he did not tell the truth under oath. She didn't do that. And that is a fairly serious ethical violation. In most states, that would be sufficient at the very least to get the lawyer suspended. And in many states, it would be sufficient to get the lawyer disbarred. Officers of the court, which is what a prosecutor is, which is what every lawyer is, officers of the court are there to ensure that the process is fair. It can't be fair when someone is telling lies about a defendant. And that's what happened in this case. As I said at the beginning, and this is important, everything is an assertion at this point. It's an allegation. Nothing has been proved. But this is a documents case. And if the documents contain what the Chief Disciplinary Counsel says they contain, and if the transcripts demonstrate that Ms. Gardner said what she said and did what she did, then there is a very high likelihood that her law license will be disciplined. There is a pretty good chance that discipline will be imposed. Now, what could that discipline be? Discipline can range from anything from a letter of reprimand, which is usually for very minor violations of the rules. It could result in a suspension of a law license. It could result in a suspension with probation, which means that the law license will be suspended, but that suspension will be probated and that she will be able to continue to practice subject to the requirements of her probation. Or she could be disbarred. All of these things, all of these options are on the table. Now, normally what happens at this point is it goes to a hearing panel where a group of lawyers, usually a panel of 3, will hear the evidence on behalf of the state or the Office of Disciplinary Counsel. And then that panel will write a report. The report will make findings of fact, reach conclusions of law, and make a recommendation as to discipline. Both parties at that point can make objections to the hearing panel's report. They can object, for example, because they don't believe the facts demonstrate what they found as facts. They can object because the conclusions of law aren't supported by facts. They can object for all kinds of reasons. If that happens, usually the case goes up to the Supreme Court. It is briefed, and then it is set for oral argument. And then the Supreme Court weighs in and makes a determination about whether or not discipline should be imposed. So that's how this will work out. Most people are not familiar with this process, and so I hope this has been useful. If it has been useful and you've enjoyed this, I'd appreciate it if you would mash the like button for me. And also subscribe. If you haven't subscribed to our channel already, please subscribe. We do a lot of different things here. We look at current events, we look at things like the Gardner complaint, and we talk just about general issues in the law. So if that's the kind of thing that you're interested in, please mash that like button and click on the subscribe icon and click on the notification bell so you can be notified anytime we release a video. Thank you for watching. Have a terrific day.